Chapter number 6, Prevention and Operation of Mismanagement. Test your knowledge question. Question number 1. ABC Private Limited is a company in which there are 8 shareholders. Can a member holding less than 1/10 of the share capital of the company apply to the tribunal for relief against operation and mismanagement? Give your answer according to the provisions of the Companies Act 2013. ABC Limited प्राइवेट लिमिटेड कंपनी है, हार्ड शेयर होल्डर है. कैन अ मेंबर होल्डिंग लेस देन, जिसके पास 1/10 शेयर कैपिटल से भी कम है, वो ट्रिब्यूनल में जाके अप्लाई कर सकता है कि ऑपरेशन मिसमैनेजमेंट में? आंसर. तो आंसर इन सेक्शन 244 of the Companies Act 2013. In the case of a company having share capital, the following members have the right to apply to the tribunal under section 241. Not less than 100 members of the company, or not less than 1/10 of the total number of members, whichever is less, or any member or member holding not less than 1/10 of the issued share capital of the company, provided the applicant has paid all the calls and all other sums due on the shares. In the given case, since there are 8 shareholders, as per the condition A above, 10% of 8, that is 1, satisfies the condition. Therefore, a single member can present a petition to the tribunal regardless of the fact that he holds less than 1/10 of the company's share capital. ठीक है, तो यही है कि not less than 100 members or not less than 1/10 of the total number of members, whichever is less. 1/10 of total number of members भी 1/10 ही, और 1/10 of total share capital, issued share capital भी 1/10 ही है. 8 का 1/10 is 0.8, that is 1, और एक आदमी बोल ही रहा है तो कर सकता है वो. Question number 2. The issued and paid up capital of MNC Limited is rupees 5 crore, consisting of 5 lakh equity shares of rupees 100 each. The said company has 500 members. A petition was submitted before the tribunal, signed by 80 members holding 10,000 equity shares of the company for the purpose of relief, a joint operation and mismanagement by the majority shareholders, examining the provisions of the Companies Act 2013. Decide whether the said petition is maintainable. Also explain the impact on the maintainability of the above petition if subsequently 40 members who had signed the petition withdraw their consent. क्या हुआ इस क्वेश्चन में कि एक एमएनसी लिमिटेड है, 5 करोड़ की पेड अप शेयर कैपिटल है, 5 लाख इक्विटी शेयर हैं 100 रुपये के, और उस कंपनी में 500 मेंबर्स हैं. तो 500 मेंबर्स के हिसाब से 10 1/10 हुए 50, और 5 करोड़ की कैपिटल के हिसाब से 1/10 हुए 50 लाख. एक पिटिशन सबमिट हुई ट्रिब्यूनल को, साइन किया 80 मेंबर्स ने, 1/10 से ज़्यादा है, जिनके पास 10,000 इक्विटी शेयर्स हैं. 10,000 इक्विटी शेयर्स मतलब कि 10 लाख, और 5 करोड़ का 10 लाख है, 10% है 50 लाख. तो 1/10 मेंबर्स तो हो रहे हैं of the company for the purpose of relief against operation and mismanagement by majority shareholders. Examine the provisions of the Companies Act. Decide whether the petition is maintainable. Also explain the impact on the maintainability of the above petition if subsequently 40 members who had signed the petition withdraw their consent. 80 में से 40 चले गए तो बचेंगे 40, तो फिर 1/10 भी नहीं होगा, कम हो जाएगा, फिर मेंटेन नहीं होगा. वैसे एक बार करने के बाद फिर विड्रॉ नहीं कर सकते. Answer number 2. Right to apply for operation and mismanagement as per the provisions of section 244. 244 ही लगता है, 244 section याद कर लो अच्छे से of the Companies Act. In the case of a company having share capital, members eligible to apply for operation and mismanagement shall be lowest of the following: 100 members या फिर 1/10 of the total number of members, or members holding not less than 1/10 of the issued share capital of the company. The shareholding pattern of MNC Limited is given as follows: 5 crore equity share capital held by 500 members. The petition alleging operation and mismanagement has been made by some members as follows: number of members making the petition 80. Amount of share capital held by the members making petition is 10 lakh. The petition shall be valid if it has been made by the lowest of the following: 100 members or 1/10 of 500, that is 50 members, or members holding 50 lakh share capital being 1/10 of 5 crore rupees, As it is evident, the petition made by 80 members meets the eligibility criteria specified under Section 244 of the Companies Act 2013, as it exceeds the minimum requirement of 50 members in this case. Therefore, the petition is maintainable. The consent to be given by a shareholder is reckoned at the beginning of the proceedings. Consent जो shareholders की रहती है वो beginning of proceeding में check करते हैं. The withdrawal of consent by any shareholder during the course of proceeding shall not affect the maintainability of the petition. राजामुंदरी इलेक्ट्रिक कॉर्पोरेशन वर्सेस वी नागेश्वर राव का केस था ये वाला, पता है मेरे को, पढ़ा था मैंने. द विड्रॉल ऑफ कंसेंट बाय एनी शेयर होल्डर, बाद में जो 40 हट गए उससे कुछ नहीं फर्क पड़ेगा, एक बार पिटिशन कर दी तो हो गई वो, फिर उसके बाद हट जाओगे तो उसका कैंसिल नहीं हो जाएगा. किसके केस में हुआ था ये? राजामुंदरी इलेक्ट्रिक कॉर्पोरेशन वर्सेस वी नागेश्वर राव. So next is question number 3. A group of shareholders consisting 25 members decide to file a petition before the tribunal for relief against operation and mismanagement by board of directors of Messrs. Fly By Night Operators Limited. The company has a total of 300 members and the group of 25 members hold 1/10 of the total paid up share capital, accounting for 1/15 of the issued share capital. The main grievance of the group is due to mismanagement by the board. The company is incurring losses and the company has not declared any dividend even when profits were available in the past years for declaration of dividend. In the light of the provisions of the Companies Act 2013, advise the group of shareholders regarding the success of 1. Getting the petition admitted and 2. Obtaining relief from the tribunal. तो इसमें क्या बोला है, 25 मेंबर्स हैं जिन्होंने डिसाइड किया कि पिटिशन करेंगे. टोटल थे 300, 1/10 होता है इसका 30 और या फिर 100 मेंबर्स. 30 से कम है, 25 लोगों ने किया है तो 1/10 तो फुलफिल हुआ नहीं. एंड द 25 मेंबर्स होल्ड 1/10 ऑफ द टोटल शेयर कैपिटल, बट जो 25 लोग हैं वो 1/10 होल्ड करते हैं शेयर कैपिटल फॉर 1/15 ऑफ द इशूड शेयर कैपिटल. बाकी की चीज़ें बतानी है आंसर में. Answer number 3. As per Section 244 of the Companies Act 2013 provides the right to apply to the tribunal for relief against operation and mismanagement. The right is available only when the petitioner holds the prescribed limit of shares as indicated below. In the case of a company having a share capital not less than 100 members of the company or not less than 1/10 of the total number of its members, whichever is less, or any member or members holding not less than 1/10 of the issued share capital of the company, provided the applicant have paid all calls and other dues on the shares. In the case of company not having share capital not less than 1/5 of the total number of its members. 1/5. अच्छा, अगर शेयर कैपिटल नहीं है, विदाउट शेयर कैपिटल कंपनी है, तो उस केस में 1/5 हो जाती है टोटल नंबर ऑफ इट्स मेंबर्स में से. सिंस द ग्रुप ऑफ शेयर होल्डर्स डू नॉट नंबर 100 और होल्ड 1/10 ऑफ द issued share capital or constitute 1/10 of the total number of members, they have no right to approach the tribunal for relief in this case. However, the tribunal may, on an application made to it, waive all or any of the requirements specified in 1 or 2 so as to enable the members to apply under section 241. अगर ट्रिब्यूनल चाहे तो ये वाली जो रिक्वायरमेंट्स है फर्स्ट और सेकंड वाली, इनको हटा के उनकी जो एप्लीकेशन है उसको एक्सेप्ट कर सकता है कम लोगों में भी. As regards obtaining relief from tribunal, continuous losses cannot by itself be regarded as operation. Ashok Betelnut Company Private Limited versus M.K. Chandrakant. Similarly, failure to declare dividend or payment of low dividend also does not amount to operation. Thus, the shareholder may not succeed in getting any relief from tribunal in this case. कि भाई कंपनी को लॉस हो रहा है, वो कोई ऑपरेशन नहीं होता, या फिर कंपनी डिविडेंड नहीं दे रही है, कम डिविडेंड दे रही है, वो कोई ऑपरेशन नहीं होता, तो उस केस में रिलीफ नहीं मिलेगा ट्रिब्यूनल से. Question number 4. A group of members of XYZ Limited has filed a petition before the tribunal alleging various acts of operation and mismanagement by the majority shareholders of the company. The petitioner group holds 12% of the issued share capital of the company. During the pendency of the petition, some of the petitioners group holding about 5% of the issued share capital of the company wish to disassociate themselves from the petition, and they, along with other majority shareholders, have submitted before the tribunal that the petition may be dismissed on the ground of non-maintainability, examine their contention having regard to the provisions of the Companies Act 2013. वही है, एक बार अप्लाई कर दिया तो फिर वापस नहीं ले सकते. Answer to fourth. The argument of the majority shareholders that the petition may be dismissed on the ground of non-maintainability is not correct. The proceeding shall continue irrespective of withdrawal of consent by some petitioners. It has been held by the Supreme Court in Rajamundry Electric Corporation versus V. Nageshwar Rao that if some of the consisting members have subsequent to the presentation of the petition withdraw their consent, it would not affect the right of the applicant to proceed with the petition. Thus, the validity of the petition must be judged on the facts as they were at the time of presentation. Presentation के टाइम पे जो facts रहेंगे उसी के basis पे judge होगी petition. Neither the right of the applicants to proceed with the petition nor the jurisdiction of the tribunal to dispose it on its merits can be affected by events happening subsequent to presentation of the petition. Petition submit present होने के बाद के event से कुछ फर्क नहीं पड़ेगा उसके maintainability पे. Okay. Now, बट अगर सारे लोग बोल देना कि हटा दो तो हटा देंगे 100%. Question number 5. A group of members holding 380 lakhs issued share capital in Zolo Limited, listed public company having total issued share capital of 15,000 lakh. As per latest financial statement, alleged that company board of directors is conducting an act which is ultra vires the articles or memorandum of the company without altering the memorandum or articles of the company. They make application to tribunal to restrain the company from doing such ultra vires act with reference to the provisions of the Companies Act 2013, ascertain whether the application will be admitted by tribunal. As according to section 245 of the Companies Act 2013, such number of member or members, depositor or depositors, or any class of them as the case may be, as are indicated in subsection 2, may, if they are of the opinion that the management or conduct of the affairs of the company are being conducted in a manner prejudicial to the interest of the company or its members or depositors, file an application before the tribunal on behalf of the member or depositors for seeking an order to restrain the company from committing an act which is ultra vires the articles or memorandum of the company. Requisite number of members to make application under section 245 subsection 1 for class action for depositors is as prescribed in the rules 84 subsection 4 of the National Company Law Tribunal, Second Amendment Rules 2019. Accordingly, in case of a company having share capital, the requisite number of members to file an application under section 245 subsection 1 shall be at least 5% of the total number of members of the company or 100 members of the company, whichever is less. In case of a listed company, member of members holding not less than 2% of the issued share capital. ये क्या है? In case of a listed company, member or members holding not less than 2% of the issued share capital. अगर listed company है तो 2% से ज़्यादा होना चाहिए. In the above case, members hold 2.53% of the issued share capital of Zolo Limited, which is a listed company, make application before NCLT or tribunal, and as members meet condition of 2% of issued share capital, therefore their application can be admitted by the NCLT. Public listed company में 2% का criteria है. So answer was this. As according to section 245 of the Companies Act 2013, such number of member or members, depositor or depositors, or class of them, as the case may be, as indicated in subsection 2, depositor or depositors, member or members, or any class of them, if they are of the opinion that the management or conduct of affairs of the company are being conducted in a manner prejudicial to the interest of the company or its member or depositors, file an application before the tribunal on behalf of the members or depositors for seeking an orders to restrain the company from committing an act which is ultra vires the articles of memorandum ऑफ द कंपनी, और बाकी की तो यही है कि एटलीस्ट 5% ऑफ द टोटल मेंबर्स ऑफ द कंपनी, 100 members, whichever is less. In case of a company having a share capital, the requisite number of members to file an application under section 245. 245 यहाँ 244 था ये, है ना? In case of a company having share capital not less than 100 members of the company and not less than 1/10 of the total share capital. सारे 244 के बारे में ही बात कर रहे थे. 244 ये भी 244. इसमें क्या अलग है? इसमें लिस्टेड कंपनी है, ये अलग है ना? और इसमें 245 लगा दिया इन लोगों ने. और इसके हिसाब से 245 के हिसाब से सच नंबर ऑफ मेंबर और मेंबर्स, डिपॉजिटर और डिपॉजिटर्स as mentioned in subsection 2, if they are of the opinion that management or conduct of affairs of the company are being conducted in a manner prejudicial to the interest of the company or its member of depositors, file an application before tribunal. Requisite number of members to make an application under section 245 for class action. अच्छा, अगर क्लास एक्शन लेते हैं ना, क्लास एक्शन मतलब कोई क्लास ऑफ डिपॉजिटर्स है, कोई क्लास ऑफ मेंबर्स हैं, तो उस केस में 5% है. 5% ऑफ टोटल मेंबर्स ऑफ द कंपनी. अगर सेक्शन 245 सबसेक्शन 1 में एप्लीकेशन कर रहे हो आप शेयर कैपिटल वाली कंपनी में, तो 5% ऑफ टोटल मेंबर्स और 100 मेंबर्स ऑफ द कंपनी विच एवर इज लेस. 100 मेंबर्स तो 100 मेंबर्स ये दोनों में. और इन केस ऑफ अ लिस्टेड कंपनी मेंबर्स होल्डिंग नॉट लेस देन 2% ऑफ द इशूड शेयर कैपिटल. तो इस केस में 2% था. डन.